Now, state recalls Ms. Burnett.
But before you do, Mr. Little, do you have any questions about those issues for Ms. Burnett or Mr. Ruiz?
Thank you, Your Honor. No, I do not.
Okay, thank you. You may proceed.
Thank you, Judge. Ms. Burnett, you understand that the obligors seeking an additional credit for the difference between the child support from January to June of this year, correct?
Correct.
And you're not in agreement in giving them that credit, right?
No.
And why is that, ma'am?
Your Honor, we respectfully disagree regarding the reduction from January 1st. The reasons are the absence of the health insurance coverage for the past 3 years and the shared medical expenses that came along with that. And the lack of contribution towards the children's sport activities that are essential to the well-being of them for the last 5 years.
What happens when child support misvisitations and years of unresolved resentment collide in a courtroom? This case is a perfect example of how financial obligations and parental responsibilities can spiral into a complex legal battle. On one side, we have Miss Burnett, a mother claiming she's been carrying the full weight of raising her children for years, covering medical expenses, activities, and daily care without consistent support. On the other side, Mario Ruiz, a father who insists he's been trying to stay involved, struggling with employment, communication barriers, and what he describes as malicious compliance. But here's where things get interesting. This isn't just about money. It's about credibility, accountability, and whether past actions should impact present obligations. Should a parent receive financial credit if they haven't fulfilled other responsibilities? Or does the law strictly follow numbers and timelines, regardless of personal circumstances?
Let me ask.
Associated with him not picking them up.
Ma'am, I'm going to stop you. No one's objected, but at this point, I think you're beyond answering the question, or it was a very broad question. So, Mr. Damasian, if you can continue and maybe streamline a little. Thank you.
Yes, ma'am. So, Ms. Burnett, I'm going to ask you direct questions, and just answer the question. You'll get a chance to speak at the end. In the prior order, who was ordered to carry health and dental?
He was Mario.
Okay. And when did that stop?
September of 2021, when he lost his job.
Okay. So is your testimony that you've been carrying the health and dental for the kids this long?
Correct.
Okay. And is this one of the reasons why you don't want to give them credit from the January to June?
Correct.
Okay. What other expenses have you incurred?
I'd respectfully object to more testimony along these lines. I don't read 156-401 as having equitable exemptions. It simply states that a child support order is to relate back to the date that he was served with the modification. So I just object on relevance grounds.
Mr. Damasian?
Judge, equitable grounds is something that's always important in trial. So I believe it is relevant.
Right away, you can sense the procedural tone of the courtroom. But underneath that formality, there's tension building. The state is recalling Miss Burnett, which usually means her testimony is critical to clarify disputed issues. Notice how the judge is carefully giving both sides a chance to object or question. That's crucial for maintaining fairness on the record. But here's the key detail. This moment signals that something unresolved still needs clarity, specifically around financial credits and obligations. When a witness is recalled, it often means their earlier statements weren't enough, or new arguments have been introduced that require deeper explanation.
I'm going to overrule the objection only because there are no reasons cited in the code. So I'm open to listening to what both of your reasonings are for why it should or shouldn't go back. It's a may, it's not a shall. So you may proceed, Mr. Davis.
Thank you, Judge. Ms. Burnett, is there other expenses that you've incurred besides the medical and dental?
Well, he hasn't picked him up according to the court order for his visitations since August of 2021. So I do have them on his weekends and his time. So I feel like those expenses goes toward the cost that occurs there. Also, she has cheerleading and baseball, and he doesn't pay any of that. So
Now,
I think it's fair.
Now, how long? Are you saying that you've covered the health and dental since 2021?
Correct.
Okay, and just a ballpark figure, how much did that cost you just for the kids during those years? During monthly figures during those years.
We pay as we did the math earlier. I pay $548 a month for the kids.
And
for health insurance and dental is $58.
Okay.
So since September of 2021, I mean, you could do the math. I don't know. That's
and the children have been covered since then to present.
Yes, correct.
Okay. All right. Pass the witness, Your Honor.
Mr. Little, do you have questions for Ms. Burnett?
A few, yes, thank you. Ms. Burnett, my client's been making efforts to see his children, correct?
Absolutely not.
Oh, so
No.
you're saying that he hasn't tried to communicate with you?
He wanted them, and I gave them the schedule. We had cheerleading competitions in rehearsal, and I gave him the schedule, and he decided not to because he can't drive right now. So he'd have to have his mother, who just had open heart surgery.
Objection narrative.
Now we're getting into the heart of the dispute, financial credit for child support. On paper, this might sound simple. If payments were adjusted, should there be a credit applied retroactively? But in reality, it's rarely that straightforward. Miss Burnett immediately pushes back, and her reasoning is layered. She's not just talking about missed payments, but years of additional burden she claims to have carried alone. Medical insurance, extracurricular activities, and even visitation gaps are all being brought into the conversation.
Narrative.
Well,
That's the question.
no, he has not. That's the answer to that.
Thank you.
And are you aware that Mr. Ruiz has been attempting to get child support review for over 2 years?
No.
You're claiming that you're not aware of that.
He filed and I received that, but he never even told me when he lost his job.
You have stipulated to state's exhibit of the child support financial history sheet, right? And that reflects that he has been paying his child support obligation for the month since the month of earlier than that,
October.
but definitely all
Yes.
year this year, correct?
But it hasn't, not the amount that he's ordered to do so.
All right. Pass the witness.
Previously to that,
Pass the witness.
Ma'am, he's passed you as a witness. There's nothing to answer. Thank you. Mr. Dehmejian, you may call your next witness.
Judge, I can let Mr. Little call his witness.
Thank you. Okay.
Mr. Little?
I'd call Mario Ruiz.
Yes.
Mario, what efforts have you made to see your children in the last year?
Phone calls, text messages. I try to call to formulate something, get something going, and it's just malicious compliance.
Okay, when you say that, can you kind of speak in more layman's terms what you mean by that?
So I try to set something up, like get information, and it's just like being put through a blender. It's not easy.
So you're not able to effectively communicate with Ms. Burnett?
No.
Okay. Has she referred you to talk to other people? when you try to talk to her about scheduling?
Yeah, so I've been referred to her husband, their stepdad. I've spoken to him once, stating the same things. Hey, we need to figure something out. What are we going to do? And nobody wants to work with me, so we have to go this route.
Now, under the current custody order, you have an expanded standard possession order, so you're able to pick up the kids from school during your times, right?
Mm-hmm.
Okay, but why does that not work for you now?
This is where things start to intensify. Miss Burnett is clearly resisting the idea of giving any financial credit, and her reasoning quickly expands into multiple areas of alleged neglect. But notice what happens next. The judge steps in and stops her. That interruption is important. In court, there's a fine line between answering a question and giving a narrative. When a witness goes too broad, it can dilute the relevance of their testimony. The judge is essentially saying, stay focused, answer directly, and don't turn this into a speech. This moment also highlights something subtle but powerful: control. The judge is maintaining structure, ensuring the case doesn't drift into emotional storytelling that could complicate legal clarity. And that control will shape how persuasive each side appears moving forward.
She withholds information, so I don't have any information, for one.
No, in terms of like, why does it not work for you to be up picking them up from school at the time school lets out on Thursday?
Work, full-time job.
Okay.
I don't have the flexibility to fulfill expanded.
Right. Because you're trying to make the money so you can pay your child support.
Yes, to pay child support and my bills and everything else.
And so have you tried to reach some workarounds on the schedule so you still have meaningful time with your children? Have you tried to have some workarounds?
Yes, I've reached out. I've reached out.
And again, what's just the general tenor of the feedback you get when you try to reach out and work things out?
It just doesn't work out. We just can't seem to communicate with one another properly as we should as co-parents.
Okay. So you left your last job when?
November.
When your decree was done, when did you lose that job?
November of 2021.
Okay. And for how long have you been seeking child support review or otherwise hoping for modification?
About a year and a half plus 2 years.
Okay.
So since that, since I left my job.
Since you left your job. So more than that.
Mm-hmm.
So you reached out to the Attorney General's office seeking child support review?
Correct.
And you've been trying to follow that process, correct?
Correct.
Okay. Pass the witness.
Mr. Damation, do you have any questions for Mr. Ruiz?
Just a couple, Your Honor. Mr. Ruiz, now you were ordered to pay the health and dental in a prior order, correct?
I believe so. I'm not sure. I have to refer back to the decree.
Yeah. And
now we shift into evidence-based questioning, and this is where credibility gets tested. Ms. Burnett confirms that she's been covering health and dental insurance since 2021, a significant financial responsibility. That's not just a minor detail. Over time, those costs add up and can influence how the court views fairness. But here's the bigger picture. She's linking financial contribution to parental responsibility. In her argument, it's not just about money. It's about who showed up and who didn't. And this is where viewers should ask themselves, should financial obligations be adjusted based on overall parenting involvement? Or should the court treat these issues separately? Because depending on how the judge interprets this, it could either strengthen or weaken her position significantly.
now you weren't able to do that because you lost your job?
Yes, I resigned from my position back in November of 2021.
Now you resigned?
Yes.
Okay, and why did you let that job go?
It was just an unfit place to work at. I had many problems working in that place.
Is it because you weren't getting along with the employees, or was it just a dangerous place to work?
I mean, I was in charge of a multi-million-dollar company. So it was, the pressure, the stress that I didn't have the resources needed to continue what they expected me to do. Prior to that, there was a workplace incident where there was people killed. So I didn't want to work there anymore.
Okay.
It was just an unhealthy place for me to be.
All right, pass the witness, Your Honor.
Ms. Burnett, do you have any questions for Mr. Ruiz?
You resigned from your job?
Yeah. Yes, I did.
When you know you have financial obligations, why would you resign from a job making six figures to be unemployed for 3 years? You mean
As I stated.
your second DWI, and that's why they fired you.
Objection.
There's a difference.
Objection.
And also,
Counsel is testifying.
Yeah, ma'am, when someone says object, please stop talking so they can make their objection and I can rule on it.
Okay.
Ms. Brewer, what was your objection?
My objection was counsel is testifying.
Oh, sustained. Ma'am, you have to ask questions, not testify.
Oh, sorry. Also, Mario, when you didn't have a job from November of 2021 until October of last year, did you, how often did you pick up your children from school and on your weekends?
Here comes a critical legal clash, relevance versus fairness. One side is arguing that the law strictly dictates how child support modification should be applied, regardless of personal circumstances. The other side is pushing for equitable considerations, essentially asking the court to factor in fairness and real-life impact. When the judge overrules the objection, that's a big moment. It means she's willing to hear broader arguments, not just black and white legal rules. That opens the door for both sides to present a more complete story. But it also raises a key question. How much weight will those equitable arguments actually carry when it's time to make a final ruling? Because being allowed to speak and being persuasive are two very different things.
Well, it was often because of our communication and my work situations.
I'm sorry, that wasn't the answer. I mean, that wasn't you didn't answer the questions. How many times? Literally, I could count on my hands. But how many times you said that you didn't pick up the children because of your work schedule, but you didn't work for 3 years. So I'm just asking, how many times did you pick up your children according to the court orders during those times that you were unemployed?
I did work. I did not have work for 3 years.
Then why didn't you pay child support in that time? Why didn't you?
I didn't have a sustainable job during those times.
So you didn't report your wages to the attorney?
No, they were garnished.
Okay. I don't see that on the record, paperwork, but okay.
Okay. Does anyone have anything further?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Okay. I am going to essentially do the modification as of the March date. You were all here. So I'm going to divide the requested amount of four and change. The 4860 divided by 2, which would give him credit of $2,430 plus the $26,928 credit would be a total of $29,358 credit. And if my math is correct, subtracting that from the 97,891.02 would leave 68,533.02 as the judgment as of yesterday.
Now the spotlight shifts to Mario Ruiz, and his testimony introduces a completely different narrative. He claims communication barriers, work limitations, and ongoing efforts to stay involved with his children. But as he speaks, inconsistencies start to surface. On one hand, He says he's been trying to connect and arrange visitation. On the other, there are admissions about job loss, resignation, and limited follow-through. And then comes a cross-examination, where those gaps are exposed more directly. This is where courtroom dynamics become fascinating. It's no longer just about what each person says. It's about how their story holds up under pressure. Are the explanations reasonable, or do they raise more questions than answers? Pay attention here, because this back and forth will heavily influence how the judge interprets responsibility on both sides.
That's what we had discussed in separate meetings with with Gary. So I think we are in agreement with that.
I know Ms. Burnett is in agreement as well, Your Honor, on that amount. So.
Okay, Ms. Burnett, you are in agreement? You have to answer yes or no.
I'm sorry. Yes.
Thank you.
My voice cracked.
And you, Judge, and the only other thing would be the court cost as per the family code. It's got to be assessed against Mr. Little's client, and we can do as billed, and we can kick that out June 18 of 2026.
Does anyone have anything they want to say on that matter?
I think that's reasonable, Your Honor.
Okay. And ma'am, anything you want to say on that matter?
No, ma'am.
I'm going to add to my ruling that I'm ordering that Mr. Ruiz pay the arrears back at a rate of $400 per month beginning July 1st, 2025, with step-ups as the child support goes down. And so it would be the amount of the difference in the amounts paying towards child support added to that arrears. What's it? $549. So it's a difference of $135. So it would be $535 with the first step up, and then it would be $1,074 with the second step up. And then I am ordering that he pay court costs to Galveston County on or before June 18th of 2026. And the state is going to draft the order based on my ruling today, and they'll be sending it to you shortly, I think, through DocuSign. Mr.
Yes.
What is the plan?
Yes, Judge, that is the plan. Now, Judge, just to be clear, there isn't going to be a trial amendment, right?
No, there was no agreement, so I'm not ordering a trial.
Okay, I just want to make sure.
Yeah, I was throwing it out there to save people some money, but they can go before another judge, and that judge can make the ruling. So yes, they are free to. We are free to stop the recording and the YouTube, and you're free to move people around as you need, Mr. Damation. Thank you, everyone, for coming in, and good luck with everything going forward.
Thanks for your time, Your Honor.
Thank you.
In the end, the judge delivers a balanced but calculated ruling, partially granting financial credit, while still holding Mr. Ruiz accountable for ongoing support, medical contributions, and arrears payments. This wasn't a complete win for either side. Instead, it reflects a common reality in family court. Decisions are often about compromise, not victory. What stands out most is how both financial responsibility and parental involvement played a role in shaping the outcome. The court acknowledged past issues, but ultimately focused on creating a structured path forward, with clear payment obligations and even suggestions to improve visitation logistics. But here's the real question for you. Do you think the ruling was fair? Should past parenting behavior carry more weight in financial decisions like this? If you found this case as intense and thought-provoking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.